Good morning. Can you all hear me okay? Yeah. Good morning and welcome to the IFC Court's official panel discussion at this year's Dubai Arbitration Week. It's great to see a great number of turnout today. Unfortunately, Dr. Shamlan couldn't be with us today, so I will be delivering the welcome note. For those of you that don't know me, I'm Noor Malabda, SAT Judge and Judicial Assistant to His Excellency Justice Samlan Swalhi, the Judge in charge of the Arbitration Division of the IFC Courts. Today, we'll be discussing, with the help of our distinguished panel, the topic of what financial institutions expect from courts at the seat of arbitration. As many of you know, arbitration is a central pillar of Dubai's dispute resolution framework, an integral component of the IFC Court's suite of mechanism, one that continues to grow year on year. This year alone, until the end of the third quarter, our arbitration division has dealt with 36 arbitration claims, representing a total value of 4.6 billion, with an average claim size of 35 million. This sustained flow of high-value finance-related disputes illustrates, in my opinion, two things. Firstly, how court users are choosing Dubai as a seat, and secondly, how they expect a court that is predictable, quick, and genuinely supportive of the arbitral process. And that is exactly how the division was designed when it was first launched in 2020, to provide clear and efficient pathway for the court's supportive and supervisory roles. It offers a specialized case management with a system that represents party autonomy while still being ready to step in quickly when court assistance is required. And as you all know, Law Number 2 of 2025 was introduced earlier this year. And this law helps strengthen and define the court's jurisdiction and supervisory powers over the arbitration seated in the IFC or otherwise connected to it. And this allows banks and institutions greater certainty when planning for cross-border enforcement or judicial support. So, what do financial institutions tell us they need from court at the seat? In 3 words: speed, certainty, and enforceability. From urgent relief and tribunal support to seamless post-award outcome. And that's the length for today's discussion. We're fortunate to have a very distinguished panel with us today, bringing perspective from the world of banking, private practice, in-house counsel, and academia. I'm pleased to introduce Dr. Umar Mohamed, Associate at Cleary Goat Lead and Assistant Professor at UAE University. We're also joined by Robert Leedsley, Regional Head in Dispute and Government Investigation at Standard Chartered Bank. Also with us, Andrew Mackenzie, Partner and Head of Litigation and Arbitration Investigations at DLA Piper Middle East. And lastly, Mohammed Abanda, Chief Legal and Compliance Officer and Board Member at ACC MENA. And I will be the moderator for today's session. We will also allow time at the end of the discussion for a Q&A. May I please ask you to keep your questions until the end. Thank you for joining us today for what I'm sure will be an interesting and thought-provoking discussion. Thank you. Let us begin by grounding the discussion in the perspective of financial institutions and primary users of arbitration. Robert, I'd like to start with you.
Sure.
So what do you look for when selecting a seat? And have you had an experience where the seat made a material difference?
Well, thank you very much, Noor, for that question. So, Standard Chartered Bank, we are a significant international bank. We have operations all over. I cover up to Middle East, 22 jurisdictions or so. So we have a tremendous variety of legal systems that we're working with and options. And the approach that we've taken is to have a series of 5 preferred seats. That is already up front, and that is New York, London, DIFC, and then Singapore and Hong Kong. We have operations in those areas as hubs. We are very familiar with them. We have good operations there. We have a lot of law firms that work with there. They have modern laws and courts which are very supportive. So those are the preferred seats. Where we have an operation in a certain market, then although it wouldn't be a preferred seat, most likely you would accept that seat if necessary, because if we're already operating that market, then it probably means we are happy enough with the court system there, that we already have a network of lawyers that we would go to use that. That would be our sort of next stage there. It can then happen that some sort of international multilateral bodies will push for more, in my mind, exotic seats, like Stockholm. You'll get it. Stockholm is obviously a fantastic place for arbitration, but we don't have an operation in Stockholm. We don't speak a lot of Swedish and so on. So that would be more of a challenge. But sometimes, there are negotiations going on. You don't always have the option, actually to impose exactly what it is that you want. So we have to be flexible and understanding. I think one of the key points are we absolutely need speed. That is non-negotiable. And we obviously work with the business team to ensure that the drafting is as good as it can be in the circumstances that we have it. So whilst sometimes you see some drafting which I would think is criminal, agreeing to a badly drafted clause is not a crime. So it's not often that we are saying you cannot do this business because the clause is so defective. What we would normally say is you should try to do it better, use the model clause, look out for certain issues. If you can't, then at least be aware that actually this is not a good clause for these reasons. It's going to add to the stress and extend the dispute worth to kick off. And the business can take a risk. I mean, that's what we're doing as a bank generally, is managing risk. And as a lawyer, we don't live in a perfect world. We can't rule out crazy claims being filed, but we can minimise the risk and cost as far as we can. And that means choosing a seat where it's New York Convention, understood model law, and so on and so forth. But again, it's not a perfect, and you're asking me about whether it makes a difference. And I think sometimes people can feel it doesn't really make that much difference. There's a lot of convergence in legal systems now, understood model law countries, similar laws. Thankfully, the acceptance of international arbitration is pretty general, and outside of some out, there's always going to be some outliers, but generally speaking, pretty robust system, which has come a long way in the last 30 years for sure. But that's when you get caught out. And I cover the region, so many of us will know there are similarities, but there are differences. And one that came to mind recently actually was in Kenya, where we had an arbitration that was going for 30 years. So we'd had some issues with it over 30 years. And it finally got going, and I got involved because it'd been like sort of $500,000 disputes. I wasn't involved. I only managed major disputes, which were $4 million. But the claimant had amended their claim from $500,000 to $250 million. That caused attention. We're trying to deal with all this sort of stuff, and eventually got to the point where the arbitrator wrote to us, the parties, and said, good news, award's ready to go, but on payment of my final invoice, which was a surprise to us because we thought we'd already paid the invoice. But he said, no, there's a new invoice and I'm doubling the charges. Yes, you're going to have to get on board with that. No, that wasn't great, but was it the same arbitrator for the 30 years? No. It's a new guy, good guy, but as I'll get on to, he knew the system better than I, because he said, oh yeah, just pay this large amount of money, but with a defendant. So we had some counterclaims, whatever, but really we're happy not to get the award, not a problem for us. Wait for the other party to pay the amount, and I'm sure we'll know about it again. Which is an attitude which I've seen in other model law country that says you've got in Kenya, we've got understood model law tweet, and they said, you've got 3 months, I think, from the receipt of the award. That's the language. Fine, well, you give us the award, we'll take a look at it and challenge it. And what was then pointed out to us a couple of weeks into the period was there's a string of Kenyan cases where they interpreted the words receipt to mean the date from which the arbitrator told you can come pick it up once you pay the money. That's obviously what the arbiter knew was going to happen. So then that put pressure back on us, because although we were confident in our position in the case, technically it's a 250 million claim against us. We didn't want to take the risk of getting a bad decision, which we then couldn't challenge because of failure to pay fees. So we had to kind of adjust our approach quite quickly. Actually, the other side also paid their amount of money, and we did eventually get the award in time to look it through. And then perhaps after 30 years, the arbitrator just said, actually, no one gets anything, everyone just go home, and it was all done. So we got some conclusions to it, but it was a situation where I had made assumptions regarding the process in Kenya on the basis of it being New York Convention and unstrong and so on. But then when you read some of the case law, they've interpreted it in a way which, to my mind, was unusual. But even when you read the judgment, I find it quite interesting because the judge says, well, yeah, I'm being told by counsel that New York, India, a lot of common law countries take the approach of physical receipts, but we're not going to do that. We think that is going to take too long. We need an official process, and we're going to interpret it as receipt means when you get that notification. So you can never take anything for granted. And then I would say, yeah, if I'd known that, would I still have used Kenya as the seat? I probably would have, but I would have gone there knowing that there is a risk that we're going to be compelled to pay extra costs.
So building on that commercial perspective, it's very important to consider how the legal architecture of the seat and the role of the court shape those expectations. Dr. Omar, I'd like to ask you. So we're observing the increase in ad hoc tribunals treating DIFC and the from your perspective, what distinguishes the DIFC courts and the courts of financial disputes?
Thanks, Simmer, and congratulations on your appointment as a SCT judge. And fortunately, Justice Shamlan is not here, but we appreciate and thank him for all his efforts on this. In regards to your questions, is that we're seeing more tribunals on arbitrations that are not necessarily speeded some anywhere, but I understand that they are referring to the DIFC courts to be at the seat. I'm sure everyone would have more insight into the efficiency and ensuring measures and the speedy way that DIFC courts provide resolution as preferred in line with international standards, as well as the DIFC comfort in being an English-speaking court, a common law court, more familiar in the financial institution globally. What I would highlight, for example, if you would answer that, if not, I can answer it in a later question, if that's the first, is that the DIFC courts provide a unique position today. Through the time that it has built its reputation, it has gone through tensions, difficulties. Critics have criticized the DIFC for multiple things, but what the DIFC has proven to be is a translator that is able to provide parties with enforceability of financial international norms into local systems. Robert had mentioned that presence is very important. And Dubai, the UAE in itself, has grown to be a capital for financial institutions, that financial ecosystem and the economy has increased, enabling the DIFC to position itself with its transparent, high standard procedural aspect to support international or cross-border arbitrations in issuing or enforcing OR. One key aspect I think is very important to note and highlight is the role of judges in all of that. So it's important to emphasize and understand that the DIFC court is not a standalone court. This is in isolation of the whole sovereign ecosystem of the country. At the end of the day, the DIFC court is a Dubai court. It's a UAE court. The strength that the DIFC court has reflected today is the ability and the high quality and high caliber of legal expertise of the judiciary. Hopefully one day it will be you, is being able to keep up and understand the international developments, whether procedural arbitration, international financial standards, market practices, and customs, while also understanding how to navigate the multi-layered pluralist system and sources of law in the UAE. Literally being actors of translating international standards with predictability against being able to enforce these against assets existing within the country, which is the whole point of having going the arbitration now. And I think, to me, one last point that I would add to that is that in a conversation that I had with Excellency Justice Shamlan, he noted that early on in the day, him and his fellow Justice Al-Hay, Justice Madhani, they started with the Financial Services Authority for 3 years, working with the Regulatory Financial Services Authority, enriching themselves and becoming experts in financial standards while supplementing their existing legal and judicial backgrounds. Enabling them today and their fellow judges to understand the financial development, keep up with the procedural developments on the international community level and the financial investment level, while also being able to support enforcement with the other authorities in the UAE.
Just adding on to that point, do you think that the GIC's common law framework only includes Spanish proceeding experience for parity amongst financial institutions?
So it definitely does. The common law system and structure supported by providing a more comfortable language that is used is something that is preferred. But if we are to say yet again, if a court system, just because it follows the common law school of thought, uses a certain language with that guarantee, it's highly unlikely, but it would be a factor into that. I think the strength of the GIFC court today is its integration within a strong and solid ecosystem of a legal system, financial and economic system. So at the end of the day, the GIFC courts, reflecting on my initial point early on, is that it's a UAE court, a player amongst other players. It's a Dubai judicial body acting in parallel or in support with the financial regulatory authority within the DIFC, acting within the legislative authority within the Dubai court, acting in line also with the Dubai courts. Similarly with the UAE. Early on, there we saw some unknown, unpredicted situations or hurdles that, due to its bold and innovative approach that the GIFC has faced. One key was in relation to arbitration cases, was the aspect of conflict of jurisdiction between two local courts, DIFC and Dubai. And through innovation, they have introduced the judicial tribunal to resolve the conflict of jurisdiction. This reflects the strength of the ecosystem, the government, the leadership in opening dialogue amongst stakeholders, authoritative stakeholders, who each have different interests, but are aiming to reach the same goal. Dubai, with its regulatory framework, with its innovation in finances, with its attractions of LDI, with its even innovation in tokenization, the virtual assets and such, provide the perfect, I would say, playground for a court of high procedural levels and a court which have judges of the highest level as well. The GIFC in turn reinforced the environment by providing the preferred mechanisms and procedures and understanding. So it's a reciprocal relationship between the authoritative governments and the UAE. And the most important point is that interest might not always align, but so long that communication and open dialogue exist, the rule of law in terms of transparency, in terms of predictability, in terms of fairness will be upheld. Financial institutions, even in my past experiences working in investment disputes, seek a jurisdiction where these things are upheld. Those that understand the international standards that they are going through or prefer, as well as being able to enforce the judgment or the award that they wanted. I think that's the second question.
Thank you very much. Having examined the structural feature of GICC, I would now like to turn to how these principles operate in practice, particularly in the context of interim measures and enforcement. Andrew, the specialist for you. How do private practice lawyers guide financial institutions on seeking interim measures, and what factors influence these recommendations?
Thank you, Joe. Can I add my congratulations as well on your recent appointment? Salam and good morning, everyone. It's a pleasure to see you all here today. Before I answer the question, I wanted to just get a sense of who's in the room, and I like to do this by means of a straw poll. So by show of hands, how many people have brought an interim application or indeed been involved in one anywhere in the world? Okay, so very healthy number, which is excellent. And can you leave your hand up if that's been in the DIFC or another UAE court? Okay, excellent. So if we're dealing with some serious experts, which is always good. So from a private practice perspective, and this was touched upon earlier by Robert, for us, the key, when we're advising client, the key aspect here is a combination or a balancing act between time and cost and risk. We want to obviously try and reduce the amount of risk, but also at the same time achieve the result we want to achieve for our clients as quickly as possible, as well as ultimately do it in as cost-effective means as possible. So from an interim measures perspective, when we're advising clients, one of the primary frustrations of private practice lawyers is if we're involved in drafting the agreement, often it's our front-end colleagues, not our back-end colleagues that are drafting. And I usually get a call at the 11th hour to say, oh, by the way, we're about to sign off on this $1 billion financial deal. Can you please do double check that dispute resolution clause at the back of the contract? And for me, it's highly unusual because I start reading a contract from the back. All the best provisions are at the back of the contract, the governing law, the dispute resolution clause, etc. Everything at the front doesn't really interest me until such time that I need to debate it in a dispute. But when we do advise them, my first question I ask to my colleagues and ultimately clients, if I'm speaking to them directly, is, well, do you envisage getting into a dispute in these proceedings, this contract, or under this contract? Do you think you'll be the claimant or the respondent? And if you are the claimant, or you think you may have still be the respondent, have a sizable counterclaim, where are the assets of the counterparty? Is enforcement going to be a challenge? And if those assets are located in the Middle East, then obviously we can begin to narrow down how we structure the dispute resolution clause. And again, one of the other facets that I find very interesting is that clients have all the options at their disposal. They can cherry pick the best forum, the governing law, of the procedural seat. And they can ensure that they leave their options open and their armoury full going forward. And sometimes they don't. And I share the concern about badly worded, almost criminal dispute resolution provisions that just say the parties will arbitrate and nothing more. Or, and I say this with some trepidation because I know banks love this, but the parties can arbitrate, but we can also go to court in the following jurisdictions, but only the bank gets to decide that. And you're just laying procedural mines into the process of the way. But when it comes to interim measures, for us, it's very important where the assets are located. You've got to also think about jurisdiction and predictability, another key pillar. We want to be able to say to clients, look, if you are going to bring an interim measure in the DIC courts, for example, we know for a fact that they will deal with the application, especially on an urgent basis, speedily, efficiently, cost effectively, and that you'll get a judge, to the point Omar made earlier, who is well experienced in a particular asset class or a particular sector. Financial institutions, and I use the term very broadly, not just traditional players in that metric. And Omar made a point earlier that banks, for example, traditional banks, do gravitate towards large-scale financial institutions that can offer regulatory certainty, legal certainty, predictability, reduce their risk. But other players in the financial institutions market actually opt for jurisdictions where those don't exist. And they do it specifically because they want to avoid enforcement, they want to avoid interim measures. And you only truly appreciate the efficiency of the DIC courts seeking an interim measure. And I speak from experience the last few weeks. I went to the DIC court over the summer. We lodged an application on the Friday. It was heard, the response was due on the Monday, it was heard on the Wednesday. We were able to move very quickly thanks to the court's responsiveness and time effectiveness. And Justice Black sat on that application. I can't go into detail about the application itself because it was sealed. But here you had a commercial court, a judge who understood the subject matter of what we were seeking. Now, in tandem with that, we brought an application for discovery on an urgent basis in another jurisdiction. I won't mention which one, but it was one of the islands, offshore islands that you can imagine. And not only was it incredibly difficult to find a lawyer that would act because of the conflicts position, there was something like 40 lawyers on the island and 7 judges. And you can imagine how long it took to go and clear with 40 separate counsel. And there aren't law firms per se, they're also advocates or barristers. To be able to locate somebody that quickly who understands the subject matter, who could understand the necessity to bring an application. These are all facets that ultimately impact our ability to seek that interim measure. So when we're advising clients getting back to the contract drafting, and I ask those quick questions, we actually get into quite a debate with the client about ultimately what position are they going to hold. Do they want to put themselves beyond the reach of their counterparty and make it more difficult, frustrate the process of seeking an interim order if they think it's coming against them? Or alternatively, do they believe, as many players in the financial institutions market do, they want quick and speedy access to interim measures, to the ability to seek an injunction or discovery or compel a witness. So that's critical. The other thing that we often debate is with clients is the idea of, well, and again, within the DFC, this is much easier, but if you're putting a seat of the arbitral tribunal, ultimately in the dispute clause outside of something like the DIFC, that will significantly impact your options when it comes time for an interim order. Because of course, there are two paths to an interim order. You can either go to the tribunal and ask them for relief, or if you feel for whatever reason you don't want to do that, you can go to the court. That decision is very easy to make if it's seated to the DIFC, because unless the tribunal is formed, I know I can go quickly to the DIFC courts and seek interim relief in a form of injunction or freezing order on assets. And those assets don't even need to be located in the DIFC, to the point that the rule were made. The DIFC has become I would call a conduit court as opposed to a conduit jurisdiction. And we know the problems and difficulties that cases on that caused, but ultimately it's positioned itself incredibly well as part of the ecosystem, that if the assets are onshore or elsewhere in the GCC, I feel comfortable telling my client, let's go to the DIFC court and seek an injunction that we can ultimately enforce elsewhere. If that seat, to Robert's point, is somewhere else, Kenya, I'm dealing with the matter in Liberia at the moment, ultimately I'm not as confident that a court will act quickly, cost effectively, and grant an injunction. I'm not calling into question the independence of the Liberian courts. It's just a question of, do they have the same subject matter experts sitting on the bench? Do they have the same level of experience? Do they have the same cost-effective approach to things? So these are all the kind of facets and assets that we look at when we're advising clients on that. But ultimately, it comes down to this issue of cost, time, and effectiveness.
Thank you very much. Just to add on to that point you were making, I'd like to ask you, how do you assess the reliability of courts in cross-border award recognition areas?
So this is too dissimilar to the interim orders aspects, but ultimately we looked to sort of 4 or 5 key areas. One is treaty and enforceability in the region. And again, the DIFC courts offer us a plethora of avenues for enforcement. And I often find it really amusing that optics play a part in this. So if you ask people where the centre of arbitration was in the world, they would give you a couple of names. I know, by the way, I think the Stockholm tourist body would find it really amusing to be referred to as exotic. That's definitely they should put on their marketing material. But if you ask people where the centres of arbitration are in the world, they'll list New York, Paris, London, Hong Kong. Dubai may get a reference from a regional perspective. They may even get a reference from an international perspective. But Paris will often be seen as the epicenter of arbitration. So the ICT it's founded and originally based. And yet to enforce an award in Paris can take up to 2 years, and usually will take 2 years, because you've got to go through the various stages and phases. I took an arbitral award, an ICT award, in relation to a dispute in Iraq. I took it here and I took it to Paris. Paris proceedings are still ongoing. That was 2.5 years ago. Here, 60 days, it was recognised, and I could start enforcing it. So the optics play a significant part, and it's important as lawyers for us to pierce that veil of perhaps misdirection, perhaps bad marketing on our part. We should do a better job of stressing the strength of this jurisdiction when it comes to enforcement. And this is not just indicative to the UAE. If you look at the arbitration laws around the GCC, they've all strictly adhered to this idea of speedy recognition of arbitral awards. The mechanisms and practical track record are equally important. We need to be able to advise the client that, and we get this question a lot about Saudi Arabia at the moment. We used to get it a lot about Dubai and Abu Dhabi. There was always this misconception that if you took an award here, it would get lost and overturned. And to a certain extent, that's true. We had some interesting decisions around whether the arbitral award had been initialed on every page, whether it had been actively signed in Dubai. But one of the things I love about this city, and having lived here now for 16 years, is that we learn from our mistakes and we correct them with urgency and efficiently. We don't make them again. You compare and contrast that to other jurisdictions where the mistake is made time and time again, and this is true in the UK as it is in Paris, as it is in other jurisdictions, and they don't correct it because they don't have Perhaps the willpower, certainly they do, but they don't have the mechanisms by which they can quickly update the law. Jurisprudence and reputation as a seat also comes into play, certainly. Again, the DIC has proven itself to be an arbitration-friendly establishment. The relationship is formed not just with the onshore courts in Dubai, but the rest of the UAE, as well as its ability to access the primary conventions, the Riyadh, the Jihad, the GCC convention, again help. But also the DIC has gone further. It's gone and signed MOUs with various commercial courts around the world. And knowing and having the comfort that if I get an award recognized here, I can go to China, I can go to Beijing, I can go to Singapore, I can go to Hong Kong, I can go to Tokyo, because of the groundwork that the IFC has done. And again, I made this point earlier, this financial institution or jurisdiction has done an exceptionally good job of ensuring that all of its major arms tie into each other. So its financial regulatory authority speaks with the court, that speaks with the overall strategy and vision of what the financial body wants to achieve, the financial reason wants to achieve, and goes beyond that to make sure that the rest of the world knows that not only are we open for business, but we want to liaise with you with respect to critical things like enforcement. And the last part I mentioned briefly is the one I already mentioned, which is the conduit court aspect. That is absolutely critical, particularly in light of not just the update to the rules this year, but also recent decisions that were issued that say that you can seek enforcement here, even where the assets are not here. So that link, that nexus that needed to exist has now been washed away, and you can arguably, as long as you can prove to the court that there's an enforceability angle, you can bring the judgment back.
Thank you very much. To add to the sector bit I mentioned in the discussion, it's helpful to examine how these issues play out within the insurance and reinsurance markets. Hamad, I'd like to ask you, there's a perception that the insurance sector is less inclined to use arbitration. Would you agree in mind?
Good morning, everyone. Yes, definitely, I agree, and I will try to justify this. But before justifying this, I will need to explain that I might be the least knowledgeable in arbitration. But again, I will justify that this is for a reason. When Justice Shamhan called me for this, I told him, look, from the insurance sector, I can speak why insurance sector are not heavily involved or aware or experts in arbitration, and why. But I cannot add anything to what my colleagues have mentioned already. They have very similar experience to basically preference relation to arbitration within the countries where we have operation or to establish centers for arbitration. But the insurance is a little bit different. Although we are a financial institution by definition, or part of the financial industry system by definition, but it's totally different for banking, investment, or for other types. And the reason for that, I was discussing with my colleagues before the session, these in the Middle East or MENA region, all the insurance contracts are part of the regulation of insurance. But before that, there is the civil law. The civil law in all the MENA region covers insurance as a contract of insurance. And in all the MENA regions, all the MENA region countries, there is a particular clause to the civil law states. The arbitration in insurance is not an void unless for in a separate agreement, in a different line, in a different font. Because traditionally, this rule came from the perception that insurance is really between an individual insured and an insurance company. Very complicated, sophisticated insurance policy does not clarify the exclusions or the coverage limits, and therefore the regulators worldwide, or at least in the civil law system in MENA, wanted to protect the policyholders. And they assume that the arbitration is not suitable for individuals for claiming their insurance claim from the big bad insurance company. And they, therefore, the regulation wanted to give this kind of protection that the arbitration clause in insurance is totally protected. It has to be in a separate agreement. It has to be in a different font. It has to be in a different color. This is how it's described in the civil law regulation. And with that in mind, by the way, this is the newest civil law in the region is 50 plus years old. This is the newest, and this rule exists for about many other tens of years, if not hundreds of. So the rule is very old, and you can understand it and accept it for the business, for the retail business and insurance. For me, as Muhammad, I have this insurance policy, and I want to make a claim. And then I discovered there is an arbitration clause. Oops, this doesn't make any sense. I just need to get my claim. I have this stress, and please pay me the claim. The regulation, the government want to protect consumers, want to protect people by saying no arbitration in insurance, unless it was this separate agreement signed and implemented all these conditions. Now, this is the history. What did this created in the minds of the legal professionals working in insurance, myself included? That arbitration is bad. Unfortunately, this is the reality. So, and to ask question, who's the expert in arbitration or had experience in arbitration in VRC? Many people raise their hand. I will ask the same question. Are you specialized in insurance and have any experience in arbitration? 1, 2, so 3.
Like a bidding war.
So the idea is it's not common and it's not usual, and there is a good reason for that. The good reason back in 1970, 1960, these old days where insurance was basic insurance coverage to protect certain claim for small amount between the bad insurance company and the poor consumer who is insuring himself or herself for a very particular claim to understand this rule. But today, as you know, we are entering an insurance contract whereby really we are insuring companies or businesses are much bigger than insurance companies. If today you ask me the insurance coverage for Burj, would we expect that if there is a dispute in this insurance company and that market, and there is an arbitration clause, would we expect the court to accept the argument that the arbitration clause is not in a separate agreement signed separately and in a different font and in a different color? Would we accept that this is for the protection of a market for the insurance company? The answer is no, because this is a very big organization, negotiated contract, a very big contract with two strong corporations that they want to treat people of arbitration. But if they didn't put it in a separate agreement, unfortunately, until today, the latest judgment I have seen in Dubai Accession Court in 2024, they are still confirming the same concept that if an insurance contract, arbitration clause is not in a separate agreement, it's not void. So this is where I say I'm not an expert. I'm very good in insurance, but I'm not expert at all in arbitration, and this is my justification. It's outside our mentality working in insurance to have arbitration or to seek arbitration. We are seeing it as something not good. Now, of course, we are also mature, experienced legal professionals, so we recognize that if the benefit for the deal is not insurance policy, it's a commercial case. If today we are entering in a certain partnership with a bank, with a very big relationship with a vendor, of course, I would love to have the arbitration. And back to the theme of this discussion, yes, diversity is very important for us for all reasons, and in particular highlighted in particular, but all the good things about knowing and understanding the value of the seat makes sense if and when we are going to use the arbitration as a method for any conflict.
Thank you very much for your perspective. In the future, do you see a shift in the industry's attitude towards arbitration, and what factors would you say might drive such a change?
The answer also is yes, definitely. I believe this is changing the perception or the way legal professionals in all the insurance industry will start to shift towards more arbitration, because we know all the good reasons for why arbitration is good. We all know that the advantages of having arbitration, appropriate agreement for arbitration with all the good structure for conflict resolution under arbitration. Now, having said that, the civil law, the barrier I have mentioned, or the history that created this belief in the insurance industry that arbitration shouldn't be the route we are going for, or we should then choose or accept arbitration in any contract. It's changing. Everybody knows the advantages. And the second fact is the nature of the relationships is changing a lot. First, the courts worldwide are now clearly recognizing the arbitration in reinsurance treaties. In reality, reinsurance is an insurance. And technically speaking, if today I'm entering a reinsurance relationship, or in the UAE under the UAE civil law structure with the same condition, I will feel much more comfortable about the normal arbitration clause in my treaty without the need to ask for separation, because I have the trust in the court that they will recognize that despite this very popular article in the civil law, the court will recognize arbitration laws in this relationship between two insurance companies, despite the fact that it's still an insurance contract. Now, we have seen this, whether locally or internationally, courts are now recognizing the validity of the arbitration clause, even if it wasn't embedded in the same contract or expanded. The second part is the insurance regulation are developing a lot, in particularly in this region. We have seen in many countries in the Middle East or the HCC region, insurance regulation equivalent with much better than the more advanced countries when it comes to regulating insurance. And this will continue to bring the standard of insurance regulation to the more advanced other established countries in insurance regulation. With that in mind, if we are ever to consider this change and giving it more flexibility to the insurance industry to use and really start seeking arbitration more, which is great for so many reasons, as we know, is to consider changing the civil law, which, despite all the good insurance regulation and all the development, the civil law is not changing in all other countries. It's there, and it will continue to be there. And this, I would say, crazy article will continue to be there. So this has to change to really see big shift and change in the behavior and going forward, the insurance industry being like any other financial institution is really involved much more in arbitration.
Thank you very much. Finally, looking ahead, the panel will consider emerging markets, emerging challenges, and how arbitral seats, including GIFC, can continue to adapt, especially in areas such as digital assets and future-focused framework. Andrew, very briefly, how should courts adapt their approach to interim measures and disputes involving digital assets and crypto markets?
This is a fascinating new area of the law to a certain extent. Sorry, a quick stop, folks, and I've got only got a few minutes. But how many people have dealt with digital assets in the context of a dispute and an interim measure? Yeah, one or two. Yeah. So basic digital assets, crypto in particular, changes the game entirely. The traditional models around freezing orders or injunctions don't work with digital assets. I can take a USB pen loaded with 500 Bitcoin, which is equivalent to transferring somewhere in the regions of $10 million, flip it into my pocket and walk across the border. You can't obviously do that with traditional assets. You can't move a building that quickly. You can't transfer assets that quickly. There's cash assets, that is. There are usually checks and balances in place. I don't believe the courts have yet caught up, any court in the world yet has caught up with the idea of how do you go about freezing digital assets in the context of either decentralized, in particular, which is very difficult, decentralized financial setups or a centralized financial setup. So if you think about it in the context of crypto, we're seeing a very large scale movement in this market. The number of disputes in this market are growing daily. There was an attack on the 10th and the 11th of October, an attack on the market, I should put. It wasn't a sort of a cyber attack, it was a crash of the market where conservatively, they're estimating about $20 billion was wiped off the market in the span of about 5 hours. And if you imagine if you're waking up on the trading floor and someone has said $20 billion has been wiped off the gold market, there would be massive panic in financial markets across the world. This didn't even warrant a major headline in any of the major financial press, which is deeply concerning for other reasons. But ultimately, what happens to those customers and clients and financial institutions and sovereign wealth funds, Abu Dhabi and Dubai are investing quite heavily in the crypto space. How do you advise clients when they have lost a substantial amount of money on a decentralized platform where you don't even know where the assets flown to? You don't know who is ultimately responsible behind it. It takes a great deal of effort, time, and analysis to look at whether this was market manipulation, whether it was a conservative attack by an external third party, which could be everyone from North Korea to terrorist financing organizations who are seeking to make quick money and move it very fast across different networks. That itself is a substantive merits and decision behind that matter takes months and years to conclude. But at the very beginning, you want to be able to say to the client, like, let's put our hands on as much of that asset class as humanly possible. How do you go to a court and explain that assets have been either the value of the assets has been destroyed, or indeed the coin itself that you were trading in has been taken and liquidated in a mass liquidation process and is now sitting somewhere on the blockchain? So you need to go to a court that's crypto aware. And again, this is where the DIFC digital court is quite substantially ahead of a number of its competitors, because it foresaw the rise of tech disputes, digital assets disputes, and has already got experts on the bench that can deal with that. You also need effectively to find a court that will understand, and we talked about this already, that the asset class you're seeking may no longer be in the IC, in Dubai, or anywhere in the region. And again, the DIC court, not just with its rule change recently, but also the case law from last year, has confirmed that you can bring an action in the DIC court for an interim measure, including a worldwide freezing order, which is very important. Because ultimately you want to be able to try and freeze the asset elsewhere in the world. I brought an application recently in another jurisdiction where I was not just seeking the asset class to be frozen, which in this case was several 100,000 Ethereum coins, but I was also seeking disclosure of the digital wallet that they related to, as well as the ultimate beneficial owners of various trades in the factual matrix leading up to the interim application. The court in that other jurisdiction, which I will not name, to David Flushes, could not wrap its head around the last two aspects of our application. So they understood you want to grab something, they've got that, the judgment with us on that. When I asked for disclosure of the wallet, he generally looked at me very puzzled, and he asked me to explain what a digital wallet was, and then how could he issue a judgment if that digital wallet was not physically located somewhere. And I tried to explain to him that, yes, it's on the blockchain in various mainframes, but the zeros and ones, I couldn't honestly say that's in Germany or that's in Canada, because it's on a decentralized platform. So he said, well, and naturally it's a practical question he should have asked me, which was, how do I go about directing the disclosure of that material? And I said, well, we've identified where the digital wallet is being hosted. Not physically, but the company that's responsible for giving you access in order to see the digital wallet. They can tell you the identity of the individual sitting behind it. And even though they're not located in this particular jurisdiction, they have links to other jurisdictions which your order would be applicable. So when you're up against the clock and you've got assets flying around the world and you've got asset classes collapsing and you've got forced liquidation, the last thing you want to do when you turn around to your client is say, this is all fine and well, and I know your world is burning right now, but we're going to take days and weeks to explain to a judge how we go about solving this. What you want to be able to do, as I did with the DIC courts quite recently, is file an application on the Friday, get a response by Monday, and hear the judge on the Tuesday or the Wednesday. And that's the experience of what it is. But courts are going to have to mature, they're going to have to learn and catch up, and they're going to have to become familiar with the terminology. And the same thing to be a specialist tax court, specialist marine court, specialist insurance court. These are areas of specialty that, certain lawyers should fear to tread in them if they do not have the requisite experience. This is very, very true of digital assets. And the more complex tokenization becomes, bearing in mind we're now talking about tokenizing real estate assets, the biggest asset class in the world, of course, it makes sense to tokenize it. How do you explain to a judge that the person who owns a token in an asset class doesn't actually own the asset class? They own the token in that asset class, which is held by X. But the real estate you're trying to seize, which is what the token is linked to, is held by Y. That's going to take some time to explain. So again, having a court that's open to that, understands the lingo, understands the terminology is hugely beneficial.
Thank you very much, Andrew. Moving on to Dr. Ahmad's perspective on this, very briefly, I'd actually like to know how can the GIC court play a central role in developing frameworks, tokenization and crypto-based arbitration?
And so just building on what Andrew has covered, the development in tokenization from cryptocurrency thus far is that generally led by common law courts, London, New York, Singapore, the IC, and based on some research that I've done with the team, with the Dubai related team on cryptocurrency and tokenization specifically, was that courts treat tokenization that if it was like a So if it's traded as a security for the purpose of security, negotiated as security, a security. If it's traded as a property, it's a property. That's the purpose that we have reached. Now the question of the potential of the GIC courts in being lead innovator in even arbitration related or general jurisprudence in relation to tokenization and cryptocurrency, I would say that history records the world. And the DIFC courts, when it was established, or the GIC jurisdiction as a whole, financial center 2004, it seemed that we were trying to achieve the impossible. The leadership, Sheikh Hamid Barashid, the Ma'an Hamid Bagawi, their vision that they wanted to implement was not seen to be realistic by many in the world. But as Andrew noted earlier on in his previous answer, that Dubai had a unique aspect is that it addresses the issues and the struggles and the difficulties that it faces, rather than just turning the other place. And it addresses them efficiently. And by doing that, it progresses and develops. And today, as Robert initially mentioned, is that Dubai is one of the 5 centers of arbitration or jurisdictions that they refer to, along with Singapore, with New York, with London, and such. GIC as a center and Dubai as a city has already proven it. It's proven its cosmopolitan composition. It's proven its well-integrated connections within the UAE and the Dubai environments. GIC entering in this niche field along the partnership or sister authorities existing within the Emirates, such as DAW, such as the Dubai courts, who are also leading in that aspect in their own way. And along with the SEA, along with the sovereign wealth investments and interest in tokenization of cryptocurrency, permits it and allows it to be the leader in the state. Supported by the relationship that it has with MOUs with multiple common law courts, going back to my original point that common law courts are the ones leading this, not necessarily because they are the only ones dealing with this, but because of the characteristics of common law structures of publicity, reasoning of the judges, and accessibility by the public. So we're seeing a lot of reasoning, we're dealing with issues, and we're seeing the reasoning, and that reasoning provides some sort of jurisprudence that we can build on. Through its relationship with globally located common law courts, its position in a strong foundational system that aims to promote and integrate a cryptocurrency tokenization system enables it to build. Yet again, as Andrew said, it's a quite niche field. We're not really sure how or where it's going. It's still things that we need to build on. It's probably even a generational gap where the newer generation would be able to understand these basic terms as basic to them. But for us, it's something of outer space. So just to wrap it up, I think the GIFC court has taken bold steps in the field. It's more equipped and prepared today to address these issues based on experience, based on flexibility and reliability in dealing with innovation, based on the environment and existing authorities that are working towards the same goal, and based on the relationship that it has built internationally. That's where.
Very much, Dr. Aman. Our last question for today is for Robert. Just to wrap up the conversation today, from a banking perspective, what could Seek do to make itself more attractive?
Well, I think it's always attractive when people are reviewing their application or trying to update them. I was at a conference and now they haven't look at their law, the English arbitration act has been updated. So it's nice that people are keeping pace. And additionally, we were saying, Mohammed, about insurance being stuck. That, you think, well, fine, that worked in the 70s, but what's working now? And creating more tools for users to employ. And I think we want to a point I wanted to make is that some of the stuff is double-edged. It's fantastic having the ability under some of these new laws to essentially strike out think about early disposal of ridiculous claims and interim measures and so on and so forth. That's all very positive. But equally, those tools can be used against you as well. So you do have to be careful. And I think there's a balance. And obviously, the seats that we use, we've been discussing, I think, strike the balance well, being supportive of arbitration, promoting it, giving people the tools to use arbitration in an effective way, but also having sophisticated judges that can help in those situations when arbitration is being abused. And we've had situations, for example, in Dubai, where we were enforcing a judgment in a local court against some property, and then lo and behold, a third party came to the court and said, actually, I own that property because I have an arbitral board here. We had a dispute, and actually the arbitrator gave it to me, and it was a total sham. I mean, it was ridiculous. I mean, thankfully, it was such a badly done sham that the date of the award was before the company was even incorporated. So, to their credit, the Dubai courts, right? No, we're going to continue with the enforcement, and they were able to dispose of that. But we saw, in London last year, there was, you may have read about this Kuwaiti award, 70-80 million dollars, and the English court enforced it because they said, oh, right, okay, it looks a bit wonky, but seems fine. Enforcement. It was only when the versions were taken that the counterparty said this was a sham. And actually, you looked at the award, cut and paste, and now we have this wonderful AI where you can go home and say, please give me an award from the LPIA, give me this and that, and it will look great. And you can throw that to some judge and maybe get it through and start causing problems. So, it is a balance, and it's one that needs to be struck. But I think those, as I said, in charity courts in particular, but other jurisdictions who are interested and active, obviously promote themselves, and that's what we want to be seeing.
Thank you very much, Robert, and thank you to our distinguished panel for their valuable insight. We're ready to take some questions from the audience. Slate policy and Mike.
Good morning, Sean Yates from Accidental Chambers. If we ignore the prevailing talk about arbitration and commercial courts not being in competition, and commercial courts not necessarily being in competition with one another, what we have is a plethora of new courts bringing up, perhaps taking from the DIFC courts. So we have the AEGM, we have the new court in Bahrain, Singapore has one. Question really for Robert and for Andrew. Robert, you have the benefit of having worked in-house private practice and at the bar. How do you choose? How do you deal with these new choices? And also, Andrew, how do you go about advising clients when there are so many new offerings apparently available and all seemingly offering something slightly different from the other?
Well, for my part, I like to take the pulse of what's going on. Work with a lot of external counsel people. For example, we have operations down the AGM more than we used to. But we've had one matter go to the AGM court, but not too much. I'm expecting more of that. So I'm interested to hear to people that have had that experience and what are you feeling about that? What's going on with arbitration in this part or those local courts, what's going on in Bahrain, operations in Bahrain. I'm fascinated to learn about that. How does that tie in with the other options are there? Because the world's a complicated place. The bank has a lot of operations, and whilst I would think probably 90%, most of the stuff is local court litigation. Like your chasing down debtors and the local courts, you should be able to do that. There's lots of other bits of business where syndicated loans, multilateral disputes, and so on, where you're not, you're going to want to choose other options that you feel may be more effective in for enforcement or substantial perspective. So it's just about, learning about it. And that's what I'm paid for. I mean, the business want to get on and do the business. The bankers, they're not that interested in some of these options, but they want to have the confidence that you can say to them, look, this is something you should take a look at. I wouldn't say that the banks are, my bank is massively unusually cautious, but we want to see a track record. I mean, that gets built up, and the DIFC has built up our reputation. Given that, we went through a lot of work to get to the recognition that it's now rightfully got, and the same with arbitral seats. What's unfortunate is, I cover 22 jurisdictions, so I can't be an expert in all of that. So sometimes I'm just hearing the headlines, and you do get some jurisdictions, unfortunately, where they get some bad judgments, and everyone's writing about it, and it will get overturned in 6 months, but you won't see newspapers writing about that. That won't be in the industry press. And then you'll be speaking to a practitioner and you'll be asking about, so what happened about this? And it's the case that you have to have the award issued in a certain, local way. And they're like, no, that's done. Well, the perception is still there. It takes time. And as we know, reputation can be lost very easily. So you want to know what's going on the ground. And the only way to do that is coming to conferences like this and meeting people and picking their brains.
Thank you very much, sir. Thanks, Sean, for the question. Dovetailing very neatly with Robert, it is very much about taking the pulse and a degree of horizon scanning as well, because I can say with confidence to a client that X court is very sensible and a good choice for either an arbitral suit or indeed to deal with commercial litigation. But of course, the likelihood of dispute arising under the financial instrument or contract could be 5 years from the date of that advice. And so we need to look ahead and say, right, where's the court heading? What's the likelihood of the bench remaining that currently sits there? Do we see any political turmoil coming along? A lot of these courts are popping up, and yes, it does give us more options. But to the point that Omar made, which is creating a commercial court with a common law background, does not in itself create a really well-run institution. And you've seen that. I won't name names, but there are a number of quasi-DIC like style courts that popped up both in this region and Eastern Europe. I've never got off the ground because they've not invested the time, they've not trained the bench, they've not engaged with the industry. One of the key drivers for us when we're advising clients is as Robert says, that track record. So we can say that with confidence, you can go to your board and say, if anything like that goes wrong, and you get asked the question, why did you choose that seat? Why did you choose that court? Well, because of all this evidence proved that they were going to do X, and just because we've got a rogue judgment in the first instance that was in the court. Or to measure how we gone our way, the evidence provided to us at the time supported that decision. It also comes back to the points we were discussing earlier about, where are the assets located, what kind of jurisdiction, and how friendly it is for its an interim measure, what precedent has already been set there, how easy it is, cost, time, effectiveness, etc., to obtain those things. So it's a myriad of different options. I like the point that Robert made, which is financial institutions, bankers themselves, they don't care. They don't want chapter and verse on the jurisprudence as much as we lawyers love to pontificate about all the different reasons why the one court could supersede another or be better than another. They just want certainty of risk as much as they can, or reduction of risk as much as they can, and they want you to come with your the best solution. And to the point I made earlier, it is about cherry picking. Just because, and we get this all the time, people are like, oh, we've chosen LCIA, so we have to seat it in London. And I'm like, no, you don't. Why do you think that? And they're like, because that's how it works. I said, no, absolutely not. You could seat it in the AGM, you could seat it in the DIFC, or you could seat it in onshore Dubai. So there's an educational piece as well. And then cutting through the optics, coming to what it says, speaking with your peer group, because none of us can be all over these forums. I'm doing a lot of work in the AGM courts at the moment as well as the DIFC courts, and have a very positive experience of both. But my colleagues elsewhere in the world may not have access to that knowledge or information, and therefore might usually go, well, it's the Middle East, you absolutely don't want to seek your arbitration there. Heaven forbid something happens. But that's a misconception on the region. So socializing it is widely as possible is key. Thank you.
Questions?
Patrick Tillman from Tiny Cody. My comments and questions to the extent of yes to Mohammed and to Robert, primarily, but anybody involved. On the insurance side, we kind of looked at lot of insurance and just to mirror that historic trend in commodities, in banking, into the shipping, sorry, I shouldn't say banking, but more on the shipping and trade side, commodities, recovery actions, reinsurance. We do see quite a bit of arbitration on that side. But of course, then there is, I suppose, on the more traditional, straightforward policy side in this region, and that's where there's a preference for the cost efficiencies of local courts, allied to, of course, the consumer protection considerations, which sometimes dictate that choice of the local courts. But in terms of big commercial contracts, I think what just to reinforce it, I think what really definitely more arbitration in the insurance, more sophisticated, larger insurance claims and reinsurance claims. And we see that certainly as being something that will continue. But I'm interested that you mentioned that insurance to a certain extent is not as regulated as some of the, in a classic banking group, there would be a lot more maybe licensed parts of the group or activities of the group that would be coming in the IFC regulation, would have cap licenses than the insurance side maybe would. But that's again there would be more regulation coming in probably on the insurance side as well. And my question is for both of you: to what extent having parts of your activities regulated by, for example, the IFC or the HGN, brings you then closer to them? And I can see that there might be an aversion in the sense that they're going to hold you to the strict standards of your regulatory obligations, including your obligations to consumers in terms of the mis-selling claims, etc. like that. But then there's going to be an inevitable amount of their activities which are going to come within jurisdiction of the IFC court. I mean, I'm coming back to the title of the seminar. As a financial institution regulated by the DAC or another offshore zone, you're going to expect, I suppose, a high standard. You're going to expect that the standards will be enforced. And to what extent is that both an attraction for your general preference for that as a jurisdiction in terms of your wider contracts, or to what extent is it perhaps where you keep them separate? We say that we've got good reasons to keep our contracts subject to the local courts in these other areas. We will, of course, be regulated afterwards and come to the DLFC courts when we need to there.
I'm happy to make some comments on that. As I said, where we have a presence, we're going to be happy with the courts, generally speaking. And with the DIFC, that is I guess, a live concern that the DIFC can have quite expansive jurisdiction. We're a branch of the DIFC. We're part of the legal entity in London. It's not the same for other institutions, like HBC, for example, the legal subsidiary. But we do then sometimes get into situations where the DIFC courts want information onshore. Because as you may know, there's no retail banking at the IFC, the accounts for onshore. But technically, that's a different jurisdiction, and we have to manage some of those expectations. I mean, technically speaking, we could be sued if someone trips over in our office in Japan, that's a branch, or you could be sued in the IFC for that. So, ways that wouldn't happen, but I mean, on the basis that that could happen, and that's just part of the reality that we have. I mean, it's interesting when we're talking about interim relief, and so what Andrew was saying about predictability is always one of the things like, yeah, it's great to have without notice applications, we use them and get out against it. But from a business perspective, that's a bit of a live wire. We don't know. I could go back to the office, open up my emails and see that actually we've been slammed with some reduced injunction. And yeah, maybe there's an undertaking of damages that we'll never be able to use. So it can be a double-edged sword, these aspects, and you have to sort of work with that. But I think it all works pretty well, because like I said, I think if you're asking me, do we have a reason not to ever go into a more sophisticated court report that we think is going to get into detail? I mean, no, that's great for us. That gives us the confidence that we know that the court is going to hopefully apply itself. I mean, you know that there's always going to be litigation risk. You don't know how things are going to play out. There are reasons why we have appeal courts. There are funny judgments all over the globe from every jurisdiction. So there's always that risk. What you want is a sensible, proportionate, reasonable process where you're going to get a nice, reasonable decision in your favour, but at least you can have the confidence that it's not because you got a bad judge. You got a good judge, maybe didn't see it your way, but he saw. I mean, that arbitration I've spoken to in Kenya for 30 years. We get an awful lot of live arbitration going on, but it does happen. But I had to tell the business, but it's going to be coming out next week, and this is how things could play out. And the amount of business people that came back to me and said, "Oh yeah, that's fine. Obviously, we just appeal when we get to the court appeal on this." And I was like, "Well, no, it's not really. It's kind of done. There's some procedural things that we're not expected to happen. But you could challenge it, but this is kind of it. And I remember getting an email from someone the bank the day before, and just a one-liner with, "We're going to win, right?" I was like, "Well, I think I've already explained that we think we're going to win." And see, thank you, it all worked out. But I underestimated how much pressure that arbitral process, that one shot, which is usually a big positive, is, and I love arbitration bits, all the rest of it. But actually, the business was so used to using courts within appeal, they just thought, okay, we get a bad decision, we get a better judge later on. And it was like, no. This is the process that we signed up to in 1995, and we had to run it through. So it's all pros and cons, but ultimately we make it.
I would really that I'm again old, but I need to bring some history. But insurance in UAE are under the umbrella of the central bank only 7-8 years back. Before that, it's insurance authority, independent authority with its own sets of those regulations. And therefore, the differentiation between different type of sophisticated insurance contracts or simple individual contracts has not been there, but we are definitely trusting that the central bank now will recognize the need for differentiation between how we treat an insurance contract or relationship and whether or not the law concepts apply to insurance relationship across the board or only the individual concept. Your point about onshore and offshore, definitely the answer is yes. So at the moment, I'm in discussion with clients for 3 of them contracts relationship, and for the 3 of them, I want you to prepare it with arbitration. More likely, we will have this meeting there. So we are not in the MOU, but this is the contract I want you to be, because I know that I'm working from PhD or offshore area. I have full confidence and that the regulator will not come or the court will not come for this commercial relationship and will ask me that this is against the civil law or against the civil or the concept of insurance that you need to have in a separate and developed. It's not an excluded, it's not an insurance policy, and the arbitration is not linked to that type of any other provision in the contract. So yes, when we have this flexibility, definitely we will go.
And actually, do you see that the aviation or shipping of commodities have be more the case there?
I personally, I didn't do any of these contracts, but I know that before this panel, I have spoken just to confirm my information with a couple of colleagues or joint councils in the UAE and outside the UAE to confirm that, guys, how often do you seek arbitration or prefer arbitration? All of them. No, it's bad. It's not you. This is how we have been built within the insurance. Now, if I remove my insurance hat and I am entering a partnership outside insurance, joint venture, specific partnership, these kind of relationship. Of course, I will have the arbitration on top of my mind. In fact, I will insist on arbitration because I understand the benefits. But whenever I'm wearing my insurance hat, regardless of the type of insurance or the significance of the deal we are entering under this insurance contract, the mindset is this is not right. This does not suit the insurance. Although it does. But the reason I have.
Thank you very much. We'll take one last question.
My question is for Andrew. That case you mentioned about the theft of the digital assets, could you just that really briefly and also more importantly, what you think the implications are for the market from either a proactive regulatory perspective or implications on litigation, especially Dr. Amar mentioned, the UAE and the GCC countries are moving more towards enabling digital assets. And so I think it's really topical and I hadn't heard of that. So thank you.
So the case is still ongoing, which is probably why it has been published. The proceedings themselves in the courts were sealed. The proceedings in the other jurisdiction I didn't mention are also sealed. As there is an arbitration, there's 5 arbitrations ongoing sitting in the background. But I can give you the overall view of the facts and the matrix that's kind of unfolding is all in the public domain. But eventually you have a situation, in fact there's going to be 2 situations. You had an attack over the summer on a specific token class where its value plummeted substantially over that period. And when any asset class, any commodity is under attack from a pricing perspective, you will have people who are taking positions on that asset class. And ultimately, if the price falls below a particular point, you get sort of forced liquidations. Margin calls should happen. People should be notified in advance. But ultimately, the market tries to adapt and prevent further risk and dissipation of the price itself and ultimately the asset class. The attack on the 10th and the 11th of October earlier this year, or last month, sorry, the purpose and the ultimate beneficiary behind that is not yet known. And one of the key areas that is still to be developed, and bearing in mind Dubai is the only place in the world that has a virtual asset regulatory authority, BARA, which I'm sure many of you are familiar with. Again, going back to the point that Dubai does horizon scanning very well, sets itself up to attract this type of business. But ultimately, you have a situation where the rules around this asset class and this industry are not yet written, neither by the regulator nor by the courts, not even by the industry itself. They don't actually ultimately know what restrictions and what guardrails should be in place. And if you compare and contrast that to a traditional commodity, take frozen concentrated orange juice. I was finding it amusing commodity to trade in, but it is regulated. It is, you know exactly what you can do in terms of trades on it. The market opens and closes at specific points in time. So you've got guardrails, you've got breaks that can be instigated to prevent too much fluctuation in that asset class. So you will not wake up one morning and find that the price of frozen concentrated orange juice has rocketed through the roof or plummeted to the floor. Highly unlikely. However, in digital assets, whether it be crypto or other forms of digital assets, we do not have those guardrails in place. Those asset classes can vary substantially. And there's part of the market that sit there and go, well, you were a fool for getting involved in such a volatile asset class in the first place. Why do you want the courts to fix what is effectively a gamble on what some people still perceive as a Ponzi scheme? And you get those who are much more sophisticated and understand what crypto is trying to do, what its purpose behind it is. And of course, we've gone from the basic cryptocurrency in the form of Bitcoin to now really complex digital assets in crypto. Some of it is pegged, USD Tether, for example, is pegged to the dollar. You've got other forms of digital assets like digital gold. The Bank of England has now finally got on board with the fact that it's the 21st century. We should be embracing things like concepts of digital gold. These are classes that are an evolution of what previously existed as a commodity. And then you still get the Wild West. And what we haven't done is sort of bring the market in and place it into a structure that ultimately can be governed by a court and can wrap your head around it. One of the biggest, ending on this one note, one of the biggest problems courts face when granting an interim measure is what harm will do if they don't, and what harm will they do if they do grant it. And of course, when you freeze a digital asset, like, take Ethereum, for example, if a court freezes Ethereum, 100 Ethereum, and then 2 days later, Ethereum plummets through the floor, and the person who had the asset isn't in the position to sell it because it's frozen by the court, that is a substantial loss suffered that may never be recoverable. And so the security that needs to be put in place around that is very difficult. But the ecosystem is changing. 8 years ago, I did my first kind of major crypto matter, where crypto was a asset class in debate between the parties. And I really struggled, my team and I really struggled to find a company that would act as escrow for holding the crypto while we did the debate. What basically put the court couldn't, and they couldn't actually freeze it because we didn't believe freezing injunction would hold. So what they did was they transferred it. We wanted to transfer it to an escrow account. All the parties debated the substantive dispute. We went to all the major financial institutions. They said absolutely not touching that with the barge pole. We went to some of the more exotic players, and not Stockholm, I need to add, they're in New York, and they said yes, we can get comfortable with the idea of holding crypto in the form of an escrow account as an asset class. Nowadays, I can name 10 that will do it. So the market is moving, the market is changing. We are catching up, but there's still much to be done.
Thank you very much, Andrew. Thank you to all our panelists for their valuable input and their time today. Thank you to all our attendees for coming today. Does anyone else would like to add anything? No? Thank you very much, everyone.